welcome to Canadian Justice. I'm Christine Van Geyn, and today we're talking about a controversial federal government program called the Court Challenges Program and a new report that has exposed some of the cases that this program has funded. Under this program, the federal government pays to sue itself, all using your taxpayer money. The Court Challenges Program offers federal taxpayer funding to approved charter challenges and interventions. The program is essentially the federal government handing millions of taxpayer dollars to lawyers and activists to sue them, and the details are all hidden from the public eye. A new report from the MacDonald-Laurier Institute has looked into the types of cases that have been approved by the program. And I think no one was shocked to learn that the funded cases could all be characterized as landing on one side of the ideological spectrum, essentially using your money to wage social justice war via the courts. Here today to talk about these findings are the authors of that report, Professors Dave Snow and Ryan Alford. Thank you both so much for joining me today. Let's start with you, Professor Snow. How much money are we talking about here? How much taxpayer dollars have been doled out uh, in your report that you've uncovered to pay for cases like these?
Thanks, Christine. So the CCP or Court Challenges Program has a budget of roughly $6 million annually. The Department of Canadian Heritage that funds the CCP gives it typically between $4 and $5 million a year, and there's a surplus every year, and that's how we get up to around six. So usually its expenses are actually between $3 and $5 million, but it often doesn't spend its full budget. Its typical surplus is usually nearly $2 million. One year it was almost three and a half. And the other thing I'd note in terms of this budget is that last year it just details how much it spends on the cases it funds broadly, and then on administration. And last year its administration budget was nearly 28% or $1.17 million. Normally it's closer to 800,000 or about 15 to 20% of its total expenditures. But I still don't really understand why this type of program would require so much in administration costs.
And with that money, how many cases do we know have been funded, or maybe how many cases get funded each year, Professor Alford?
Well, in the past 6 years, it was 345 cases, and which is quite a substantial number. It should also be noted that the success rate of people applying to have their challenges funded by the Court Challenges Program is very high. It's actually been over half over that time period.
Do we know anything about the cases that don't get funding, or is that just kind of lost into the ether, Professor Alford?
Maybe we can just foreshadow this before we talk about the ideological bias in the program. But given the fact that the vast majority of the cases, virtually all, align ideologically with the progressive end of the spectrum, and also quite interventionist and advocating for more governmental intervention and, in fact, more governmental largesse, it's quite possible that the ones that don't get funded are the ones that argue in the opposite direction.
But at this point, there's not that much transparency from what I understand. Professor Snow, what can you tell me about the transparency that does exist around this, and how this committee that is supposed to determine which cases get funded, how they reach their conclusions? Do we get any insight into that at all?
Very little is the short answer, and I would say in answer to your previous question, we don't. They don't give any reasons for why they fund cases or why they don't. Their only transparency is a roughly 20 to 25-page PDF annual report that they put out each year. And up until this most recent year, they have not provided any information on who they funded. They use the language of litigation privilege on its website, its guidelines, its annual reports. This has been defined by its director in a parliamentary committee hearing as intended to safeguard litigants' privacy rights so that the parties can go about mounting and pursuing their case free of interference. But quite frankly, no one has ever been persuaded by this as a reason why, if I get funding in my own research through a social sciences and humanities research council grant, they put my name on the website, they say how much funding I got. I don't know why that would stop any of these organizations or individuals from, pursuing their litigation, knowledge of where the funding comes from. So all that we do have is that the annual reports list 4 to 6 example cases, anonymized, but sometimes easy enough for researchers to figure out, of who they funded and what that argument was. And so they've done that for the last 6 years. And then this past year, they listed the cases that they funded that had ended, but with one line of text, and oftentimes in a way that's impossible to figure out who they funded. Sometimes you can glean it. but they hide it all under the language of litigation
Wow,
privilege.
wow. We've got to go to commercial break, but we'll be right back, and I want to talk about how you as researchers determined which cases were at issue here. We'll be right back. Welcome back to Canadian Justice, where we're discussing the Court Challenges Program, which is a program that gives taxpayer money to social justice activists to sue the government. Professor Alford, you and Professor Snow have written this report where you've gone through and determined which cases this program actually funded. But as we were discussing in the last segment, it's not just as easy as, cracking open the annual report and saying, oh, here's the list of the cases. How did you actually figure out which cases were getting funding, and how hard was that to do?
It's very difficult with respect to interveners. That required going and looking on the court's docket and looking at various memoranda filed on the court's website, and then trying to track the language that's revealed in these anonymized or quasi-anonymized surveys that the program itself puts out. But we were in fact able to find out which were in fact funding parties. And some of those were quite shocking insofar as the anonymous or anonymized report doesn't really give you a good indication of how controversial the matter actually is.
Yeah, let's talk about some of the cases that you found. Professor Snow, maybe you could give me three examples of funded cases that really stood out to you as surprising that the government would fund a case like this, and something taxpayers might not want their tax dollars going towards.
Sure, yeah, I'd be happy to. So, I mean, the first one, and the one that maybe has gotten the most news, both from this report and Blacklock's reporters' excellent reporting, is that the Court Challenges Program funded two interventions in the greenhouse gases reference. So, this was the provincial challenge to the federal Trudeau government's climate change plans, and this was or policy, I should say. And this is a federalism case. This is about, do they have the jurisdiction, or does the provinces have jurisdiction? It's not a charter case at all. And so we had to sort of glean that presumably some intervener was making some argument related to rights. And just logic, it defies logic to suggest that there would be a rights-based argument that this program or policy shouldn't exist. And so we surmise, and the CCP seems to have confirmed in correspondence with Blacklock's reporting, that they funded interveners making arguments in favor of the government's existing legislation. Another example and I might be mispronouncing the name, and I apologize, the Tepamboa case, where the Court Challenges Program funded the party to the case. And these were two individuals who were spouses who had been denied entry in or denied refugee status in Canada because it was found by the Immigration Refugee Board that they are likely have to committed or contributed to crimes against humanity while part of Robert Mugabe's Zimbabwe national army. And so, I mean, that's the most shocking one, right? And the argument is sort of, in that case, it went to the federal court. This case ended up losing and being denied appeal at the Supreme Court of
I just
Canada.
want to articulate what you said. So the government is trying to deport an individual who is alleged to have committed crimes against humanity in Zimbabwe. And the government's position is these people should be removed from our country. But then the government funded a group to support them, arguing that they should stay. Is that what the case is?
Yes, I mean, in a few words, yes. There is sort of a technical legal argument that this came down to an interpretation of how to interpret this statute regarding refugee protection, and that the Supreme Court had issued a new decision, and therefore that had changed the jurisprudence, and now these people ought to be considered. The courts did not agree with that at every level. But yes, effectively, the government is saying these two people who were already found likely to have contributed to crimes against humanity as part of the Zimbabwe National Army, we're going to fund their litigation when they try and change this Immigration and Refugee Board's mind and ultimately become refugees in Canada. And they were coming from the United States. Complicated decision. But yeah, so that you asked for three cases. I don't know if we want to move to
Yeah,
Professor Alford, but those are the two that stick out in my mind the most.
yeah, and before we go to the next to your examples, Professor Alford, maybe you could tell me about the ethical question of the government funding an intervener in support of the government's case. I mean, I have questions about that being ethical. It's sort of like using taxpayer dollars to pad the government's own case. Just 30 seconds, briefly, what your thoughts are.
I guess that's the problem is that you see it as vouching. The notion is, well, we're not quite sympathetic enough to make this argument, but we'll fund someone or some organization that has a very kind of good public image to essentially to articulate arguments that track our own. Uh, there's a real problem there with kind of transparency and also with how courts are being treated, whereby you're getting an argument smuggled in by somebody who might not be held to account the same way that the government is.
Yeah, and all at taxpayer expense. We've got to go to commercial break now, but we'll continue this when we come back. Welcome back to Canadian Justice, where we're talking about the Federal Court Challenges Program, which a new report has uncovered has been using taxpayer dollars to fund social activism cases against the government. So it's sort of bizarre program here. And the authors of that report, Professors David Snow and Ryan Alford, went through all of these cases that got funding and have written about it in this new report from the MacDonald Laurier Institute. And some of these examples really stand out as strange decisions of cases to fund. Ryan, can you tell me about the cases that really stood out for you?
Well, some of these cases would have very broad effects if the arguments being made by the people funded by the court challenges program had those arguments accepted by the courts. The most interesting one, most potentially far-reaching for me, was a case called Seklani, where a portion of the Immigration and Refugee Protection Act was challenged pursuant to Section 7 of the Charter. Essentially, the argument was that people who had already made refugee claims in the United States would be then allowed to come to Canada after having had that refugee application denied by the United States, which has quite a detailed and quite defensible system for the adjudication of those claims, and then make those claims again in Canada, and that not allowing them to make these serial claims, despite the fact that they're coming from what's called a safe third country, was somehow contrary to the charter. If that had been struck down, what we would have seen was essentially a Roxham Road type exemption being applied all across the country.
Hmm. And you had another example as well, or
Absolutely. There's another case where the issue in power was whether or not legislative acts of the Parliament of Canada could be the basis for damage awards. It took quite a lot of digging to find a connection between the intervener that was likely funded by the Court Challenges Program and their arguments. But essentially, what they were arguing is every single time that the courts could find that the legislation was extended in various ways by Parliament, that could be the basis for another damage award. Given the kind of matters that they were discussing, we would talk about essentially serial awards of up to billions of dollars against the government of Canada through this novel liability of the Parliament of Canada.
I mean, power is actually a case that the charity I work for, the Canadian Constitution Foundation, intervened in. I can tell you right now, we did not get any taxpayer funding for that intervention, nor did we seek it, nor I think if we had sought it, would it have been granted? Because one of the things, Professors Alford, that you pointed out is that there seems to be a theme that emerges from the types of cases that get funding, and it's an ideological theme. What can you tell me about that?
Well, it's interesting because they're funding challenges that would have more liability for the government. If you're intervening, effectively, you're saying, well, no, people shouldn't have recourse. We shouldn't have an expansion of a right. We shouldn't have more possibility of getting damage awards from the government of Canada. We're not seeing any of those. We're only seeing funding of interveners and parties that are arguing essentially for either expansion of state power or more access to governmental programs.
Although, frankly, Professor Alford, I would object to them funding an intervener that pads the government's case as well. I think I honestly, I just think that the whole program doesn't make any sense and probably shouldn't exist. And I think when you look at the ideology of the types of cases that do get funding, it really indicates that there's bias at play here. But Professor Snow, maybe you could explain who actually is the one making these decisions, and maybe that will give us some indication of why they're leaning one way or the other. Where are these people coming from? Sort of where are they drawn from, and who chooses them?
So yeah, the interesting thing is in the interest of or along the theme of lack of transparency, the website says, okay, we've got two expert panels. They currently consist of 7 people. I was looking at them as recently as this morning, and it just lists their names. It doesn't even give a bio. It doesn't. So you have to do some googling to figure out who these people are. And so each panel, the human rights panel, the language rights panel, they each contain 7 people, and most of them are law professors. The human rights panel has 4 law professors and a couple of sort of community directors at broadly speaking, progressive left wing advocacy groups. Language rights, same thing, mix of law professors and a few other. And so this program is run out of an institute at the University of Ottawa, and I do believe that I don't believe that Justin Trudeau has a phone and he's telling them go fund these litigants. That these expert panels are actually assessing the applications and making their decision, but they're composed, primarily of people whose CVs, it's quite clear, have a progressive ideological orientation. I should say I know a couple of professors who have sat or do sit on the language rights panel, and they do excellent work. But it's very clear that this is not promoted as an ideologically progressive program, but it is in terms of its
Hmm.
output and its personnel.
We've got to go to break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the Court Challenges Program, a federal program where the federal government pays to sue itself using your money. Now, you have written this report exposing some of the cases that have received money. Professor Snow, what has the public reaction to your report been so far?
So we private reaction has been good. We got lots of positive feedback. One piece in particular, written at the Canadian Bar Association's publication called National, was really critical of our report, and I think indicative of the way that critiques of sort of these national progressive programs, how you go about these critiques. So, in particular, the author argued that the heart of our report's argument was the claim that the CCP aligns with the Liberal government's priorities. After reading this article, this response, which upset me a bit, we use the word liberal 6 times, and 5 of it is just describing how the program was created in the past. We used the word progressive 40 times, and our main method we used is we looked at these 26 annual report descriptions. We coded them as progressive or conservative. We were aired on the side of neutrality, and we found 96% of the time it was an obviously progressive legal argument that they were funding. Nowhere does this article mention that we did that we went through these cases, that we looked at the annual reports. It owns in on one sentence where we say the ideological priorities of the program align with the Liberal government. And so I do think that's indicative. It says at another point that our arguments have already been debunked. To our knowledge, this is the first investigation of this program at all. Journalistic, the program is reinstated in 2017, 18. Ours is the first to look at it. Maybe someone can look through these and say that we were wrong about it, but certainly it's interesting to call it debunked. And then finally, this sort of this piece makes what we call a sort of classic bait and switch. They say it's only $5 million. Why are you even looking at this? Look at the other ways that the government wastes money and these sorts of things. And I am all in favor of reports that look at ways the government wastes money, but to suggest that it's a drop in the bucket and therefore it isn't worth evaluating the use or misuse of taxpayer dollars, I think is a real problem. That's been the only real public response that I'm familiar with. Perhaps Professor Alford might have seen more, but that seems to be the one big one.
Yeah, Professor Alfred, anything you want to add there on maybe the general public's reaction to this report, if you've seen any of that?
I think the public understands that this is quite a substantial amount of money, especially given that we've made the argument that, I mean, this is just the initial investment. In a certain sense, it's like seed money. You pay one of these interveners, law is made, which now expands the field for damages against the government of Canada. Particularly in one of the cases that I mentioned previously, we're talking about billions or even tens of billions of dollars. So that's really the true cost. The notion that there really is only a positive benefit because this is about making sure that things are constitutional. Well, there's always a particular view as to whether or not something is constitutional or not, and it's really suspect that the government is essentially getting 2 bites at the apple by funding people, especially when that would lead to damages against the government or indeed Parliament.
Now, what's the conclusion of this report, Professor Snow? Do you think that this program could be reformed? Do you think it should be canceled? Do you think a different government might use this program to fund different types of cases? Since as I understand it, it is the government who appoints the people who decide the cases. So, I mean, if progressives like the program now, they might not like it if it continues to exist under a conservative government that might fund conservative cases. So, what do you think the future is for the court challenges program?
I think that very much depends on who the government is after this next election. It's a program that tends to have been created by liberals, canceled by conservatives several times in our history. We call for the cancellation of the program. We don't think that governments of any ideological stripe should be funding their friends to litigate against them. You've made this argument quite persuasively today, and I think
I've made it
fundamentally
before. I've made it
and you've made it
before.
before, and we cite you in the piece. But I don't think the program can be saved. And I think in particular part of it is the focus on Section 15, the equality section of the charter, lends itself to sort of progressive ideological
Mhm.
arguments. So I think in terms of transparency, in terms of centralizing power in the federal government, all the reasons we've suggested, it's not worth saving. We don't need it, and it should be gone.
Couldn't agree more. Professor Snow, Professor Alford, thank you so much. We've heard today about the Court Challenges program and a new report outlining some of the cases that our tax dollars paid for. What do you think of the government handing out your money so it can sue itself? Should the program be scrapped? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.